Today we're looking at 20 real estate exam questions on discharge of contracts. If this content helps you, then please help us out. Subscribe, hit the notification button, give us a thumbs up, and comment below. So here we go. What does discharge of contract mean in real estate? A, the initiation of a new contract. B, the fulfillment or termination of a contract. C, the notarization of a contract. D, the breach of a contract. B, the fulfillment or termination of a contract. Discharge of contract refers to the completion or termination of a contract either through fulfillment of its terms or through other legal means. Which of the following is not a method of discharging a contract? A, performance. B, assignment. C, novation. D, breach. B, assignment. Assignment transfers contractual rights or obligations to another party but does not discharge the original contract. What is the most common method of discharging a real estate contract? A, novation. B, breach. C, performance. D, rescission. C, performance. The most common method of discharging a contract is by performance, where both parties fulfill their contractual obligations. What is novation in terms of contract discharge? A, the substitution of a new party to perform the contract. B, the termination of a contract due to impossibility. C, the mutual agreement to cancel the contract. D, the assignment of rights to another party. A, the substitution of a new party to perform the contract. Novation involves substituting a new party in place of one of the original parties to the contract with the consent of all parties involved. Which of the following can discharge a contract due to impossibility of performance? A, mutual agreement. B, natural disaster. C, assignment. D, notarization. B, natural disaster. A natural disaster can make performance impossible, discharging the contract due to impossibility. Before we move on to the rest of the questions, if we've helped you, then please help us. Like, subscribe, hit the notification bell, and comment below. Thanks. What is a mutual rescission? A, unilateral cancellation of the contract. B, an agreement between parties to cancel the contract. C, a court order to terminate the contract. D, a breach of contract by one party. B, an agreement between parties to cancel the contract. Mutual rescission occurs when both parties agree to cancel the contract, returning any exchanged benefits. What is the effect of a breach of contract on the discharge of the contract? A, it automatically discharges the contract. B, it always results in mutual rescission. C, it may allow the non-breaching party to terminate the contract. D, it has no effect on the contract. It may allow the non-breaching party to terminate the contract. A breach of contract may give the non-breaching party the right to terminate the contract and seek damages. What is the purpose of a release in contract law? A, to assign the contract to another party. B, to formally terminate the contract. C, to create a new contract. D, to modify the terms of the contract. B, to formally terminate the contract. A release is a formal agreement where one party relinquishes its rights under the contract, effectively terminating it. Which of the following can discharge a contract due to frustration of purpose? A, performance. B, mutual rescission. C, impossibility. D, a change in circumstances that destroys the contract's value. D, a change in circumstances that destroys the contract's value. Frustration of purpose occurs when an unforeseen event undermines the principal purpose of the contract, discharging it. What does accord and satisfaction involve? A, assigning contract rights to a third party. B, substituting one contract for another. C, resolving a contract dispute by agreeing to new terms. D, terminating a contract by mutual agreement. C, resolving a contract dispute by agreeing to new terms. Accord and satisfaction involve the parties agreeing to new terms to resolve a dispute, discharging the original contract. What is the primary purpose or primary difference between discharge by performance and discharge by agreement? A, performance requires a court order, while agreement does not. Performance is unilateral, while agreement requires mutual consent. C, performance involves fulfilling contract terms, while agreement involves mutual consent to terminate. Performance is involuntary, while agreement is voluntary. C, performance involves fulfilling contract terms, while agreement involves mutual consent to terminate. Discharge by performance occurs when contract terms are fulfilled, while discharge by agreement occurs when both parties mutually consent to terminate the contract. What is specific performance? A, the substitution of one contract for another. B, a remedy requiring the breaching party to perform as agreed. C, the assignment of contract rights. D, the rescission of a contract. B, a remedy requiring the breaching party to perform as agreed. Specific performance is a legal remedy requiring the breaching party to fulfill their obligations as outlined in the contract rather than paying damages. What happens to a contract when it is discharged by mutual consent? A, it remains in effect until all terms are performed. B, it is modified to include new terms. C, it is terminated and the parties are released from obligations. D, it becomes voidable. C, it is terminated and the parties are released from obligations. When a contract is discharged by mutual consent, it is terminated and the parties are released from their obligations. Which of the following is an example of a contract discharged by operation of law? A. Performance of all contract terms. B. Breach of contract. C. Bankruptcy. D. Mutual rescission. C. Bankruptcy. Bankruptcy can discharge a contract by operation of law as the debtor is released from their contractual obligations. What does it mean when a contract is discharged by accord and satisfaction? A. The original contract is fulfilled by both parties. B. The parties agree to new terms and discharge the original contract. C. The contract is terminated due to impossibility. D. The contract is assigned to another party. B. The parties agree to new terms and discharge the original contract. Accord and satisfaction involve the parties agreeing to new terms, which then discharge the original contract. Which of the following scenarios would likely result in a contract being discharged due to impossibility of performance? A. One party changes their mind about the contract. B. The subject property is destroyed by fire. C. A minor breach of contract terms. D. One party assigns the rights to another. The subject property is destroyed by fire. The destruction of the subject property makes performance impossible, thus discharging the contract. What is the legal consequence of a contract being discharged due to frustration of purpose? A. The contract remains enforceable. B. The contract is terminated and both parties are released from obligations. C. One party must pay damages. D. The contract terms are modified. B. The contract is terminated and both parties are released from obligations. Frustration of purpose terminates the contract, releasing both parties from their obligations. What does it mean to rescind a contract? A. To assign the contract to a third party. B. To modify the terms of a contract. C. To cancel the contract and return the parties to their pre-contractual positions. D. To discharge the contract by performance. C. To cancel the contract and return the parties to their pre-contractual positions. Rescission involves canceling the contract and restoring the parties to their original positions before the contract was formed. How does a mutual mistake affect the discharge of a contract? A. It makes the contract void. B. It results in specific performance. C. It allows the contract to be rescinded by mutual agreement. D. It has no effect on the contract. C. It allows the contract to be rescinded by mutual agreement. A mutual mistake allows the contract to be rescinded as both parties were mistaken about a fundamental aspect of the agreement. What is the result of unilateral mistake in the discharge of a contract? A. The contract is automatically void. B. The contract is enforceable against both parties. C. The mistaken party may seek to void the contract if the mistake is significant and the other party knew or should have known of the mistake. D. The contract is automatically modified. C. The mistaken party may seek to void the contract if the mistake is significant and the other party knew or should have known of the mistake. A unilateral mistake may allow the mistaken party to void the contract if the mistake is significant and the other party knew or should have known about the mistake. Well, if we helped you, then please help us. Like, subscribe, hit the notification bell, and comment below. I hope you do well on your test. Thanks.